Hi, my name is Mackenzie Holland. I'm a reporter at Tech Target, where I cover federal regulation of big tech companies like Google, Amazon, Apple, and Facebook. Today, I'm going to be talking to you about one method enforcement agencies like the Federal Trade Commission and Department of Justice use to stop companies from growing too big: antitrust lawsuits. But these cases take time and can be difficult to prove. For more information on this topic, please click the link above or in the description below. U.S. antitrust laws, namely the Sherman Act and the Clayton Act, stop companies from making acquisitions that would significantly lessen competition and prohibit monopolistic business practices. The more than 100-year-old antitrust laws are what U.S. judges base their decisions on when hearing antitrust cases. As the appetite to rein in powerful tech giants grows, and past acquisitions like Facebook's acquisition of Instagram and WhatsApp cause U.S. Congress members to question the law that allowed these mergers to happen, there is a desire from some in Congress to update the old antitrust laws to better address modern businesses. That is, large technology companies with rapidly changing and growing digital products. Senator Amy Klobuchar has introduced legislation to update the laws, though updating the laws is controversial, as some experts argue that the laws have functioned effectively for 100 years and don't need to be changed. However, some experts like William Kovacic, professor of law at the George Washington University School of Law, said legal precedents over the past decades have supported less intervention in the market. Take the recent Epic Games versus Apple antitrust case. Epic accused Apple of monopolistic business practices over the handling of its App Store after Apple removed Epic's popular Fortnite game from the App Store. After months of witness testimony, including from Apple's CEO Tim Cook, U.S. District Judge Yvonne Gonzalez-Rogers decided the court could not conclude that Apple is a monopolist under federal or state antitrust laws. Kovacic said the decision was evidence of the cautionary trend the courts have set when it comes to antitrust cases, meaning federal enforcement agencies like the FTC and the DOJ will have a tough time making antitrust lawsuits against powerful tech companies stick based on the current antitrust laws, including the FTC's current antitrust lawsuit against Facebook. Though Kovacic said that there is a case to be made for updating antitrust laws, it's not likely to happen anytime soon. Updating laws as established as the antitrust laws will take time, and it may not come soon enough to help cases like the FTC's antitrust lawsuit against Facebook succeed.